King, I'm not sure if you've seen these motions. Have you seen them yet, or just received them?
I have not seen them, Your Honor. I have honestly no real idea what they request, but I would say that the filing of the governor's executive order divests Ms. Ayala of any jurisdiction to be a party in this cause. The governor has appointed me. There is a case that I can cite to the court. It's called Austin versus Christian. It's out of the Florida Supreme Court. It was decided in 1975. It's 310 Southern 2nd, 298. And it says that the governor, for any good and sufficient reason that he chooses, can assign any state attorney to go anywhere in the state of Florida and handle any case. I submit that it's hard to get around that kind of authority to say that I'm not allowed to be here.
I'm not sure I'm ready to fully hear that issue today. First, you haven't seen the motion, so I'd like you to have an opportunity to see it. And it includes a motion to stay the proceedings, which would affect Mr. Loyd's procedural rights. And so what I'm thinking is that we might try to hear that next week. In other words, give both parties an opportunity to be heard. If I understand Ms. Ayala, she's saying that she doesn't object to your participation at this time, and because the state's under certain deadlines, intends to work with you. Whether she can work with you is another matter, but intends to work with you until that issue is resolved.
That's a correct assessment of my position, Your Honor.
Now, whether she has any authority is something that I'll entertain. I just don't want to do it on the fly, which is this morning.
Yes, sir. And that's my biggest concern, was what I had thought I had heard her say, that she had filed a motion to stay the proceedings, and that obviously is my big concern, because given the particular circumstance of the case, I don't think she has any right to file a motion to stay. And if there is any action on that stay, there are deadlines that occur that may or may not survive appeal if this court enters a stay that's unjustified because the filer had no jurisdiction to file.
Right, we're getting a little bit ahead of ourselves. I think what we ought to do is, in a minute, pull out our calendars and see if we can hear this matter sometime next week. We're not going to do that exactly yet. One thing that I did notice this morning that's in the court file is a notice filed by the state of Florida of its intention not to seek the death penalty. And that's in the file now. Whether that remains the state's position or not, obviously is open for debate and discussion. But right now, you're aware that that's in the court file?
No, sir, I was not aware that was in the court file. And I am not aware as to when it was filed.
I believe that, let me just take a look at it because I've got a copy of it here. I believe that it was filed on March 16th. It was e-filed at the...
Also previously represented, also currently represent Javonta Hayes on another felony case, and previously on possession of cannabis. Those charges against. We have prior representation of.
Here's who has chosen to represent himself, and we've had a variety of Feretta hearings. I want to appoint him standby counsel. I appointed your office and asked you to give me conflicts. What I understand is your office has said, well, Judge, if we're just purely standby counsel, we're not sure if we have conflicts. If we become the actual counsel, we will have conflicts. And what I'm trying to set up is that if Mr. Loyd changes his mind, or I find in the future that his competency is such that he no longer is able to choose knowingly, freely, and intelligently that he should represent himself, that the standby counsel would step in. And this is, I'm sure, a procedure you're familiar with.
Yes, it is, Your Honor.
And so I really want a counsel who doesn't have these conflicts. And so I'm going to remove you from the case, order that regional counsel advise me within 5 days whether it has a conflict, and maybe, I see Mr. Dean's here.
Mr. Dean is here, Your Honor. We
Maybe he
emailed
can
him.
come forward and tell me if he knows that already, and if he does, then I'm going to appoint someone from outside of those two offices, because what I'm hoping to accomplish is getting Mr. Loyd a standby counsel who might become counsel if we get to that point, if we cross that threshold. And so, Mr. Dean, since you're here, I don't know if you've met Mr. King and Mr. Ridgway, but if you'll announce your appearance for the record, and then you can address me if you're ready. Maybe you're not ready. I don't know.
Jeffrey Dean from the Office of Criminal Conflict and Civil Regional Counsel. We started to look into this, and we're aware of it from the time Mr. Loyd was arrested.
All right.
I don't think we do, but we might. And there is a couple of names that I've already spoken to Mr. King about, and it depends on how they're going to proceed. One of them involves, well, we might. And I don't think we do, but we might.
Okay.
So,
How much time do you need to make a decision one way or the other?
well, it really would be, it would really require us to know, and I'm not sure Mr. King is going to know, or if it's Ms. Ayala, who is going to be a witness yet. And so,
Has a witness list at all been filed?
It has. It has.
I mean, we
That's
approached
not-
the bench.
Just,
Well, not yet, just,
Okay.
So a witness list has been filed.
Judge, let me correct that. The attorneys who are actually prosecuting the case, Ms. Barra and Mr. Williams, our president, if I can ask him to stand, has a witness been filed?
Your Honor, Deborah Barr, on behalf of the state, we gave the Public Defender's Office the list of witnesses that we anticipate to use. So they did have a full list, but a formal witness list has not been filed.
Okay. So, Mr. King, any objection if I direct that you and Mr. Dean sit down and at least review potential witnesses together so he can determine whether he has a conflict and advise the court by 5 p.m. Friday?
No, sir, I think we should be able to do that.
Okay, so that's the order that I'll enter, that I would like you all to confer with one another to see if you have a conflict by Friday at 5. You can advise me in including whether you do or don't. If you do, I'm going to appoint someone from a wheel, and if you don't, then I'm going to appoint your office.
Yes, sir.
Okay, great. Thank you.
Thank you, Your Honor.
There's a matter, and Mr. King, I'm going to invite your participation in this. Ms. Ayala, I'd love to hear from you too. I have, of course, found on 2 occasions that Mr. Loyd is competent to choose to represent himself, and as I've pointed out repeatedly, the choice isn't whether Mr. Loyd, is able to effectively represent himself. I advise everyone you should get an attorney to represent you in a criminal proceeding, but whether he can knowingly and intelligently and freely make the choice whether or not he'd be competent is a different matter. I have some concerns in light of the proceedings last week, time we met, and some of the statements that Mr. Loyd has made. And some of his behavior, part of those behaviors, really been okay. And I am contemplating appointing an expert to examine him for his competency, at least one expert, and report back to the court. Do you want to be heard about that at all?
Judge, if I just may for the record, I do have every intent to honor the governor's order. Whether or not I believe it is lawful, I do not want to interrupt these proceedings. So based upon the order, at this point, I'm going to allow Mr. King's office to sit as counsel, and I'd be prepared in case the governor acknowledges that his unprecedented order is unlawful.
All right, Mr. King.
And I have no objection to you appointing an expert.
I do.
All right,
And I know you haven't put us in there yet, but
Right.
is there any urgency to do it since it's gone this far? Because I think you should have a lawyer. And so I'm not comfortable with the court.
Mr. Loyd has chosen not to have an attorney after 2 lengthy conversations with the court about the disadvantages of representing himself in the pretrial stage and the trial stage. And I found him competent to make that decision, but I have at least a reasonable question in my mind about his competence.
He doesn't even have standby counsel right now. And so there's no urgency for the court to enter an order at all until at least one of those issues is determined.
Well, let's talk about this for a moment. Let's say you become standby counsel. It sounds to me like what you're doing now is what counsel would do as opposed to standby counsel.
You haven't appointed me yet,
Right?
but I would, if you appoint us to be standby counsel, I'm going to ask that you appoint us to be his lawyer.
Well, that raises constitutional concerns.
It does, but they need to be raised. And right now, the issue that I understood you to say was that you're thinking about appointing an expert, and I would ask you not to do that until he at least has standby counsel.
All right, I'll tell you what, since we're going to meet next week, I'll reserve ruling on this till we meet next week, because by Friday, you're going to know whether you're in a conflict situation or not.
Yes.
And one issue that I think is obvious to all of us, and I hope it's obvious to Mr. Loyd, is that there is a clock that's ticking away, and there's not a lot of time on that clock. In other words, this trial is set in May, and we're almost at April. And while cases of this nature often are continued, they're not always continued. And the state's got to comply with the speedy trial deadlines. And so we're getting into a compressed period of time, and that's a concern that I have.
Yes, sir.
But I will wait till I hear from you, and when we meet next week, then I'll make a final decision about that.
Yes, sir.
Examination.
Thank you.
All right, if we get together for another status next week, is there a morning, the 27th, 28th, or 29th that works best for you, Mr. King?
28th, Judge Miller.
All right, that's good for me. Any issues for you if we meet on the 28th?
Not that I know of.
Is 9 o'clock all right?
Yes, sir.
All right, 9 a.m. on the 28th. Here's what I intend to take up on that day. Whether Ms. Ayala has jurisdiction to file any motions in the matter. So in essence, the motion to stay. Whether there is a conflict for Mr. Dean's office. And whether or not to have Mr. Loyd examined by an expert for his competency to proceed. Those are the three matters that are obvious to me. Is there any other matter that I'm overlooking? There is the effect of this notice of the state not to seek death. We can talk about that on the
Yes.
28th also.
The only other thing I would ask, Your Honor, is not necessary. necessarily a critical stage of the trial, but I would just prefer if the court would just ask Mr. Loyd if he does want to continue to represent himself.
I think that's a fair point. Mr. Loyd, at all material stages, we have to have that lengthy conversation we've had twice. It's called a forensic inquiry about your desire to represent yourself. But it is a fair request that I ask you anytime we meet whether you've changed your mind about that, whether you want an attorney appointed to represent you. And if you do, I'll appoint an attorney to represent you at no charge to you. So do you want me to appoint an attorney to represent you? You want to continue to represent yourself? We're going to talk about that every time we meet. You understand that, right? Okay.
But I do want, I want proper medical attention, which they not giving.
I'm not aware of any medical attention that's an issue for you one way or the other. And if you have a lawyer could help you with that too.
Well, on the rest, my jaw got broke, my nose got broke, my eye got broke, bone in my eye got broke. I had to have surgery to take my eye out because I don't have eye no more. I got trauma to my brain and I have constant headaches. I can rub my hair in my head. I can't lay down when I have headaches. I put in grievance forms. They're not answered. They're not getting answered. I put in grievance forms. They have a CAT scan on my head. I had an abscess to come to the top of my head, but they had to squeeze pus out of my head from stuff going on the side of my head. They didn't give a CAT scan on my head, which I had blunt trauma from. I got kicked in my head. I got hit with pistols and everything to my head, and my jaw broke, my eye out, my nose broke, kicked in my back.
All right, Mr. Loyd, these issues may likely have some bearing on my decision about whether to have you examine the information you're giving to me. And the other issue is, if you had a lawyer, not only could they prepare your defense, but I think that they could help you with those issues. I don't operate the jail, I don't manage the jail. And I'm not sure what they are or are not doing on your behalf. So I think we're going to talk a little bit more about that next week too. In fact, Madam Court, I'd like a transcript of this proceeding. You'll provide one to both parties. So we'll talk about that next Tuesday.
And also, I've been trying to do research on my own, study or whatever. But at night, they don't let me come out during the day. I'm in administrative confinement, which I'm supposed to be allowed the same opportunity as any other inmate in general population, but they come out day and night to use the telephone. They allow everyone else well to come out at night to use the phone except me. And they will start the curve right there. I put in the grievance, he tried to let me come out. People hold him, stop. For no reason at all, just being vindictive. So they hindered me from representing myself also.
I did talk to you earlier about how difficult it would be to fully research your case if you were in custody and a lawyer could be doing all of that research on your behalf.
Regardless how difficult it is or not, the jailhouse is still hindering me on a personal vendetta.
Okay,
They
we'll
would
talk about that next
they
week.
would start like that. He'll even tell you that they're not allowing, but they allow everybody else.
All right.
In the same position I'm in the same housing.
Okay, Mr. Loyd. We'll talk about that next week because if Mr. Dean becomes your attorney, I think he'll address those issues with the court too. Or if it's not Mr. Dean, we'll see. I mean, he wants to be your lawyer if he doesn't have a conflict as opposed to just advising you. And that's an issue we're going to have to talk about. Because if he doesn't have a conflict, will be your standby counsel, which means he's just there if you have questions for him. He's already indicated to me he thinks I ought to appoint him, but we're getting ahead of the game there. So we're going to be able to address all of that next Tuesday. I think we'll be here for a little bit of time. Okay? All right. Anything else?
Yes.
All right, we're in recess. Thank you.
Tuesday, the 20th.
I guess I sent you guys anything.